to ask his questions, Commissioner.
Okay, thank you, Chair. Senior Counsel, I'll just call you SC.
Thank you.
Now, I looked at the sample writings, and I want specifically to go to the award that you made in an arbitration. I must say it's very well written. This I noted was a matter where a construction company was claiming over 600 million shillings, I think, and but you found there was no basis in it, and instead you entered an award in favor of Kenya Rural Roads Authority. Now, what I've noted is that in capturing the issues and all that, you are very particular about the issue of the evidence vis-a-vis the claims that were made, and ultimately you found that the evidence was not one that would allow this claim that was being sought by this construction company. Now, I would want just to understand, and this is the only issue probably I'll ask on in respect to the sample writings, is that because you would be called upon, of course, to make decisions similar to what you did now here as an arbitrator. Now, the key considerations, particularly when it comes to public entities where there is the taxpayers' money involved in arriving at a decision where there are claims. I mean, what are the principles now that come to your mind when it's guiding you in that process? Just in a nutshell.
Thank you very much, fellow counsel, Commissioner. I haven't reread the award, but my recollection is very clear. I believe the landscape, our legal landscape is replete with similar claims, where when you're looking at the claims, there are so many zeros, but when you focus on the evidence, there is very little to back it. So I mean, for me, my hands are tied. I cannot award in favor of such a claimant. The same principle has always driven me, even as an advocate. And to this extent, I don't attract claimants who have very weak cases, because I interrogate the case. I interrogate the issue, and I always simply say, this is not worth fighting. That's always been my philosophy as a person. The courts, again, what is related to this is I've often heard it said that there are so many claims against the government and so on. And whilst I think in many cases the government deserves to be found liable where appropriate, there should be no hesitation for a court to find otherwise. So really, that's all I want to say about that.
Yeah. Now, public interest cases, because particularly the Supreme Court, you become our Chief Justice, it's an area that you are likely to have many of those matters. Now, I would want to hear your views regarding balancing private, against the public interest, because an area that we normally are confronted by. I'm not referring to the criminal matters, I'm just referring now generally, because it's an area where even the Constitution itself, it protects private rights, but again there's the issue of public interest, which has to be balanced. I don't know, in your thoughts, when this now your judicial philosophy, what guides you in balancing the two rights? Because this is something you'll be confronted with, every day.
The first thing that one needs to achieve, or one needs to aspire to, if one becomes a Chief Justice, is to have a reputation for being fair. It's a very simple thing, but at the same time can be very elusive. And I want to go back to something I had mentioned earlier. As soon as I joined the Department of Public Prosecutions, you come in with a reputation. If you are known to be corrupt, it comes with you. And as soon as it comes with you, the strangest of people walk into your public office asking for favors. It just happens that way. There's also another flip side of that coin. And in that office, those who cannot work in any other way often ask for transfers or to leave the office. Now, I'm coming to the issue of the Office of the Chief Justice. These claims that you're talking about, multi-billion shilling claims and so on, there are many that are genuine, but there are many that are rent-seeking claims, in the sense that they are made for the purposes of somehow procuring the judgment and ultimately getting the payment. I, as a Chief Justice, would like to have a situation where the government is assured that under my watch, fraudulent claims will be carefully handled, scrutinized. At the same time, where claims are deserving of merit, deserving of award, I will be the first person and always the last person to defend the judicial officer concerned. So create a situation where everybody is comfortable. Everybody says, well, if we have that head of the judiciary there, then let's take the judgment, whether it's painful or not. So I want to bring a situation where we sanitize the creeping image of unchecked corruption in the judiciary.
Yeah. Now, I'm trying to go beyond that. I hear you and I associate with what you're saying. But I'm talking about now the public interest component, where you find that sometimes there's the rights that would benefit the public, but there's also the component of the private right. Say, for instance, like public land, that has been not properly, granted to a party. They claim that I'm the third owner, I'm the fourth owner. But again, the institution, the public interest that has to also be taken into consideration. Probably there's the road, there's like the Mitubel case, where they'll say, yes, it's government land, but we've been here in generations. I'm just trying to understand what to guide you without going into how you would rule, because I agree with you. Sometimes it will be difficult for you to take.
Compulsorily acquire, compensation must be paid promptly and at the required level of compensation. But on the issue, and I don't want to say too much because there's a big trend of these cases in court. I generally take the view that somebody who has stolen something is incapable of giving somebody good title. And the person who then is deceived and buys the second, third title should have recourse to the person who sold it to him. So that has been my general attitude about these competing claims on public land and so on.
Okay. Now, let me come to the issue of the challenges that we face every day as advocates in courts. But you see, we as advocates, we represent the public, so to speak. Now, I know you've mentioned them generally, but now, I don't know, what are the three key challenges that we are now facing? That, you said that the ship is basically coming to a stop. You mentioned about IT and all that.
Yes.
I'm interested in knowing how you'd go specifically into resolving those issues, so that even as you resolve, because there will be those that short, medium term, and long term. There are others that you may not even be able to handle unless, of course, you are funded. But there are those low-hanging fruits, the immediate things that you think you can be able to deal with. And for instance, I would want to hear about this issue of, say, like a transfers. If you come in here, how you'd handle those kind of things, like the transfers in the institution, how you would be able to deal with the issues of optimal use of the resources that you have, including the human capital, the efficiency issues, because they are ripe issues. Sometimes you may be talking about very big things, but there are also the small things that could make a big difference without necessarily even requiring financial resources. So about some 3 key things that you would do that would quickly make us now start moving in the right trajectory.
Thank you very much, Commissioner. I start with the low-hanging fruit, the one that is free of charge. As much as a lot of stuff has been posted about me, I also read what is supposed to be relevant within this conversation. For example, the memorandum submitted to the Commission, not to me, to the Commission by the KMJA. That is the Kenya Judges and Magistrates Association, whom Commissioner represents on this commission. It is just about leadership. It's just about how that cadre of officers feel taken for granted, how they felt neglected by the immediate past administration, how they felt their matters of transfers were dealt with in a less than humane manner. I have the memo. It's a whole catalogue of things written with, I'd say, the pain of young professionals. They talk about transfers not considering the age of their families, and I understand that to mean that whilst a few of us here can, because of our age, can work in a different town from their spouse, at a younger age it is difficult. And they also deal with the transfer policy. I'm aware there are transfer policies, I mean personally, and you would understand why. I'm aware there's a transfer policy in the Court of Appeal, and I have seen how it has affected my own family. But now that there is a transfer policy, anyone's family, and mine included, could plan, because we would have the presence of the matriarch in the house for 2 years, and thereafter she wouldn't be there. I mean, whatever years, whether it's 1 year, 3 years, whatever. So if there isn't a transfer policy, and I'm going into the realm of speculation, it is suggested in that memo that there isn't. A transfer policy should very quickly be developed in the High Court and in the magistracy, and which includes the Qadis, and then it is strictly adhered to, bar the exceptional cases where, of course, for disciplinary reasons or for arresting bad situations, transfers deserve some immediacy. So the human resource issues for existing staff are low-hanging fruit. What it requires is a caring, feeling, walkabout leader. Walkabout, just going everywhere to understand the problem and attending to it as fast as possible. It reminds me, as I said earlier, of my tenure when I walked into the state law office in the Department of Public Prosecutions. And the smallest of things change people's attitude towards you, towards their own work. I mean, these days I noticed there's a lot of food in public service. You go to every corner, there's a mandazi, and if you are in the presence of the commissioners, you might be invited for lunch, and so on and so forth. There's a lot of it. When I was DPP, a small story, the office felt very motivated by the end of the year, and they said they wanted a Christmas lunch. And I said, well, I'll write a memo to the accounting officer and ask if they can sponsor a Christmas lunch for the department that had done very well. And my memo was rejected. My request was rejected. And they said, but we still want a Christmas lunch. And I said, okay, let's do a deal. Raise half the money, and I'll raise half the money as your boss. And the day of the lunch, my personal assistant came and said they didn't raise any money, but they still want lunch. I had to buy the lunch. Well, no problem at all. But what I'm trying to illustrate is it looks like there is a cadre of officers in the judiciary that feel a little neglected. And that word I use reservedly, a little neglected. That is a low-lying fruit. We need to attend to them, attend to the small things that affect their workspace. And it could just be showing them that you appreciate them.
Yeah.
The other things that now come to my mind, more substantive, and some might be short-term. You mentioned output and so on, and backlog. Well, maybe we can leave it then. You can ask the next question,
Yeah,
and
sure.
then maybe I'll deal with the bigger issues. You are talking about short-term and medium term.
About equality, treating everybody fairly, whether high
Or low.
or low, which
Yes.
is good. Now, when it comes to the law, sometimes if we look at the public, the public gets the impression that, even when it comes to the application of law, the high and mighty will be treated differently. The law, will be treated differently. Even when it comes to how bail will be handled, how judgment will be handled, their cases generally, they'll say that it seems like the rich and powerful will get away with issues, but if you are a small guy, you are treated so harshly. Now, I do not know, again, if you are to become our Chief Justice, how you'd be able to go about in ensuring that the institution is seen to be one that is treating everybody the same, even in application of law. Of course, you're not the one who will be determining cases because you'll have many people below you. But you are the leader. At the end of the day, when things are going wrong, they'll be saying it's the Chief Justice who has this institution that only serves the rich and powerful. How would you go about it in restoring that confidence?
Thank you. And this is another good point that requires collaboration at a much higher level. The biggest, what you have just described about rich and poor is it can simply be described as corruption, because the big man or the richer man gets his services, and it is presumed by the smaller man that he has more money. It's not that the system turns a sort of a control button so that it attends to people who have more money and less. No, it simply means those who pay under the table, those who are able to manipulate the system, get their services. You may have seen that in my CV, which I haven't had the occasion to look at. I, at some point, was, and I might be wrong on this, in 2002, I was a member of the National Steering Committee on Anti-Corruption. It is probably time to go back to that point where all arms of government recognize this problem as a fairly acute problem, or a crisis problem, and begin to deal with that. And of course, when you deal with it, it cascades down to the public servants, that everybody is watching them, that you cannot favor anyone over another. You must treat everybody equally. It will be a tall order for the judiciary to turn this around by itself, but it can try. It can try. It can have, of course, mechanisms where people can report this type of discrimination. Yeah, but this requires collaboration with entire government.
Which brings me to the issue of even in our profession, this is something that's a complaint that keeps arising, where some who are more senior can get away with anything and everything. The junior ones have a very rough time, making even sometimes even making their way with, in the institution of the judiciary when it comes to representation. How again would you go about it to ensure that, and this is something that is alive among lawyers generally, where they want everybody also to be treated equally when it comes now to representing their respective clients, regardless of their status, regardless of who they are. Not to say that we don't respect the seniors, of course, that title you possess is one that we all aspire for. But when it comes to representation, everybody is treated the same.
Everybody is treated the same. The lawyers are treated the same, or the clients are treated the same?
The lawyers represent the clients.
Okay.
So you want these lawyers to also be treated the same when it comes now to the services within the institution of the judiciary. There is no lawyer who is given more prominence than the other when it comes to access to justice for their clients.
Macharia, you're putting me, Commissioner, you're putting me on the spot regarding the status called senior counsel.
No, I'm not talking about the senior counsel role. I mean, there are many senior lawyers who are not necessarily having the SC title.
I thank you for that clarification. But I want to say this, and about senior counsel, and I hope they are watching. The privilege of being conferred with the status by the President on recommendation of your peers is one that any senior counsel should exercise with utmost humility. With utmost humility. So that if you go to court and the judge or the magistrate does not call you out, your seniority requires that you simply wait your turn. I've had this discussion with many of them, and the true seniors, I call them the true seniors, who appreciate the fact that with age, with seniority, with experience comes a certain responsibility. All accept that. There are a few senior counsel who go jumping up and down in the court and disrupting proceedings whenever they walk into a court, and they give the senior status a bad name. Now let me come to the profession of senior lawyers, profession of advocacy. We have a tradition of respecting seniors, and Mr. Njeru, for the Commissioner Njeru, for the time I've known you, which is many years, you have always referred to me as senior, even though I didn't have the status. But because I am, you're senior. This is part of the tradition that has been passed down over the centuries, that allow advocates to be referred to as a noble or an honorable profession. But I'm sad to say that has watered down to almost zero. Today, the lawyers who practice on social media carry the day. When I say carry the day, not necessarily in court, but they take all their arguments out. They browbeat magistrates and judges. When they get their orders, they call the particular magistrate or judge the best. When they don't get their orders, they denigrate the judicial officer. They call them corrupt. They call them gatekeepers. They call them all sorts of nasty names, agents of the state. It's a time for reflection for the profession. There are many solutions to this. Maybe some will involve legislation, but the bar is at crossroads. And in that quarrel, in that melee, in that confusion, these impressions that you're talking about come about. They come about. And if you look at the profession a little closer, it's not even seniors versus so-called juniors and seniors having access. It is a question of those who go around bullying everybody that seem to have the day in court. We need to work on that. The judiciary is the first place that needs to work on it. It needs to slow these people down. It needs to respond to these people. And for example, when an advocate, no matter who he is, no matter how senior he is, whether or not he has 1 million so-called followers, and I put it in quotes because in those situations, they probably don't exist. It's all a virtual world they live in. When you call out a judge and say the judge is corrupt, the Supreme Court is corrupt, I am hoping and expecting that one day, and it might already have happened, I don't know, but I hope the JSC can summon such people and ask them to explain themselves. That way, the profession will clean itself out and be respected.
What I'm looking for, SC, is because see, there's also the debate of the young lawyers actually who also complained to me directly as their representative that they seem to have that when the judiciary is handling them, they are treated differently from the seniors. In terms of the seniors can get away with murder, the junior. So I'm interested in hearing, you as a Chief Justice, how will you drive the message home with the judiciary so that this access to everybody, whether low, whether high, both the public and also these lawyers?
Commissioner, that problem is as old as the profession. When I was growing up in the profession, and all of us were growing up in the profession, there is a tendency to accord the seniors, because of their wisdom and experience and all the rest of it, a little more time. And it becomes a challenge on the part of upcoming lawyers to attain that status or that respect from courts. And when I was a junior state counsel in Kisumu, as much as I was starting out, I made my cases, I made my reputation, and whether or not I was working for the government, I earned my respect. So it's perhaps something we can work on at the JTI whenever there is training. We can ask the judges to be a little soft with regard to perceived preferences, but at the same time, what do they have at the legal profession? It's called what do they have? What we attend, the continuous legal education. I think some of our instructors should be able to guide the younger lawyers on what it takes to earn your space, earn your respect before any court. But otherwise, if it's a question of being there and simply expecting respect to accrue to you, that is probably impossible.
But I hope you'd also create a platform to engage lawyers of all cadres.
I recall fondly how Chief Justice William Mutunga would be invited to the annual events, the annual events of the Law Society, and I'd be happy if I was the Chief Justice to, spend some time discussing it.
Okay. Now, my last three questions. Now, question number one. You see, if you look at the common law in UK, because this is one of the countries that does not have a written constitution to date, and the development of the law was generally through the common law, and that's what we even studied in the university and all that. But it was able to shape the country, the commerce and industry, the way life is, the way people live in the UK, and you can say generally that even that law has been applied in most of the Commonwealth jurisdictions. Now, I don't know if you became our Chief Justice, how you'd go about shaping development in this country in so many spheres using jurisprudence, where we can use the law not necessarily to take over the responsibilities of a parliament, but we're able to interpret the law and develop jurisprudence in a manner that you can see that the country, the judiciary, is playing its rightful role in development of the country. Whether it's human rights, whether it's economic development, the thinking of people and all that, because sometimes the other arms could fail in taking the appropriate steps in shaping how the human society is evolving.
This is something that has cropped up in one form or another in the questions that I've already answered. If it is left entirely to the Supreme Court, it may extend to activism. I think it is more collaborative and should be more collaborative than that. The gaps in the law should be legislated first and contributed to by all stakeholders, of course led by the Honorable the Attorney General, so that the law is written clearly, it is applied in a very easy manner by the courts, and we head in a certain direction. I see the danger of leaving it all to the courts and then having this discussion all the time about activism and whether or not it was what was required or intended by the framers of the Constitution. It is a collaborative idea. It's an excellent idea. I thought you were going to ask me about developing indigenous jurisprudence, and I have noticed in one of the cases where Chief Justice William Mutunga was talking about, which was the gender issue, the 2/3 gender issue. Even though he mentioned it, he promptly thereafter continued to quote English cases. So it's not that we wipe out all common law decisions and precedents and disregard them. I think we can always apply them with necessary modifications, and we will proceed in the right way for the betterment of society, and less issues of interpretation. I do agree the judiciary, I do agree the law can play and should play a great role in improving the socio-economic aspects of our country.
Okay, my second last question. Now, there's this issue that keeps arising when it comes to elect opposition, such as yours, of the Chief Justice. Should it be somebody from the outside? Should it be somebody from the inside? Because in the judiciary, we'll all agree also has its own dynamics. Not that I have any position, but I just need you to be able to explain to us. And you see now, like when I was looking at somebody like John Roberts, the current Chief Justice of U.S. Supreme Court. And what I noted is that he clerked at some point in time, worked as the Attorney Generals, just like yourself. In fact, I see a bit of that similarity between you and him. Then worked in the White House as a counsel. Then went back to private practice 14 years, argued 39 cases in the Supreme Court, then again appointed as a Court of Appeal judge in the DC Circuit Court, then nominated by, I think it was George Bush who nominated him to go to the Supreme Court, but William Rehnquist died before the process was over, and then he was nominated as Chief Justice. So I don't know whether that's you could find that probably could disadvantage you in terms of that you're a very good lawyer, there's no doubt about that, probably one of the very best in the country in terms of understanding the law and arguing your cases with vigor. But perhaps again, because of lacking the judicial experience, somebody could probably argue that it could disadvantage you in terms of the learning curve and understanding the dynamics of the institution, and probably jump to the Supreme Court first, then become our Chief Justice. I don't know. I would be interested in hearing your response. Not to say that I have an opposition on it, but just for you to be able to satisfy this commission that, notwithstanding the lack of the judicial experience from the inside, of course you'd say that you've related a lot with the judiciary, that it still does not disadvantage you.
Thank you very much for that very good question, Commissioner Njeru. The debate about the insiders versus the outside. Let me go back a little. My favorite example is when I went back to the DPP's office. I was an outsider. I might have started my early life there, knew enough about it, especially where the shoe pinches. And when I came back, I wasn't asking what is the problem. I was simply demanding a solution. I was going to the solution. And there's a small little dimension there as well. We had problems agreeing on terms about my terms of service. And there was an interesting debate because I was taking over from a person who had been at the rank of Chief Magistrate in this court and had become the DPP, whilst there was the Honorable Bernard Chunga, who had been a DPP and had moved to become the Chief Justice, and his terms of service at that time were Court of Appeal terms. Listen to the analogy. When I came in and somebody said, here's the job, this is what you will take. And I said, no. And they said, well, why are you fussing? You wanted a job, take a job. And I said, I'm not here for the money. I'm here for doing a job, and I will do it at the level that it is required to be done. It took 5 months for them to see my point, and they gave me the terms. It wasn't much money, by the way. When they increased it to Court of Appeal, as you all know, it's much more even now. But it was the principle. And at some point, in a meeting with the office of the President, not the President, I'm talking about the representatives, When they wouldn't move, I said, then in that case, I'm prepared to leave and I will work with you as a consultant. And they relaxed a little. I got what I wanted. And just to show you the nature or the kind of person I am, they offered me a permanent and pensionable job. I said, if I can't do it in 3 years, I don't need to be here. And they gave me a contract instead. But that contract was too long. I was sacked in 2 years. Now, I come to the inside-outside discussion in the judiciary. I take my hat off here without any reservation to Chief Justice Emeritus Willie Mutunga for everything he has achieved. Sitting here today, the credit for transformation goes to him unreservedly. And why was he able to achieve the impossible? Because he went in there with a clean sheet, listened to everybody, and could very easily say, then in that case, if that doesn't work, we drop it. As against that, there is the insider candidate, for example. He's done the same thing the same way for 35 years. When you ask him to remove the glass in front of him, and he's had it there for 35 years, he says, but how can I do that? How can I do that? So whenever an institution is in crisis, and I believe this one is, a crisis of confidence, crisis of a leadership problem with vis-a-vis other arms of government, the best solution is the outsider who simply comes to ask what are considered silly questions. Why aren't we solving the problem? What is so difficult about X or Y? So this is one of the reasons that informs my application. I should make it very clear that at this judiciary that we all depend on, you got it right, we as practitioners, we as a country all depend on. If I felt it was running perfectly in the right hands, I would have been the last person to apply for the job. Because at my age, I'm going to 60, I enjoy my peace and quiet as a private citizen. Why am I coming here? And whether or not I am a good Chief Justice, I will not please everybody. I will get, as already has happened, people throw stones at you, idlers and other people who have nothing better to do. That is the nature of public service. But I believe at this point in time, you would do very well to have a courageous outsider with the necessary experience. I hope I've answered your question.
And you've answered. Now, my last question. The chair is very strict with time, so that to strictly...
maybe I should add to that last question. And who is also courageous enough to get rid of the cartels that are stalking the court corridors, that are stalking the administration of justice, the brokers for justice. They're all billionaires. They don't even charge legal fees. They're lawyers, many of them. They just charge brokerage fees. People who think they own the courts, and without them the courts can't function. That is what the courts are facing right now. The judiciary is facing that. People are losing hope. You talked about young lawyers losing hope whenever they're in a court and a senior counsel is addressing the court. There are many senior lawyers who now know if they are up against certain lawyers, they don't stand a chance. So what we need is a bit of a shake-up here. We need to move to the next level. We need to restore the transformation journey onto the right trajectory.
Okay, thank you. Now, my last question. If you become the Chief Justice, you'll be our chair here. You'll be the one now to handle this commission. And some of us, including myself, are also difficult when you are fighting, of course, for a position that, you are coming to bring issues that for the people who have elected you as the commissioner is only natural. And also our profession, we also generally also difficult. So if I don't perform, they put me under pressure. So I also become difficult here. Now, it will be the leader of the entire institution of the judiciary, the president of the Supreme Court, chairing the National Council of Administration of Justice, So all these different roles that require you to wear different hats. Now, of course, you are aware that there are those who have questioned your temperament. Personally, I've never had any issue with dealing with you, so, it's not about me. But, we are all not the same. Now, there's an opportunity for you probably to answer that question regarding how do you go about it to ensure, because they'll see us in the past, you've narrated how you are the DPP, didn't agree with them. You've projected a journey. So I don't know what kind of an assurance you'd give that you'd still be able to, in all these different roles, notwithstanding the questions being raised about your temperament in terms of, handling all these positions, that you'll still be able to do it and let the institutions run, because once you become the Chief Justice, the issue of 2 years like in the DPP does not arise. Removing a CJ is a tall order. You have to run the course. Over to you.
Thank you very much, Commissioner Njeru. First of all, my temperament is a very calm one. And I don't think there's anyone I know, perhaps maybe I know one or two people who have ever seen me get to the point where I have lost my temper. I don't lose my temper. I'm very patient. I'm very, very patient. I give you the classic example. The false accusations by Nelson Harvey, the LSK chairman, suspended LSK president. He has been on my back for the last 1 year. I have not responded to him at all. Because why should I?
Yeah, I'm not sure.
I'm trying to explain that if I'm giving you an example, I don't respond. But when I am finally forced to respond, when I say forced, the commissioner, the commission, the JSC commission required me to respond. And if you saw my response, I said it is only because you have asked me. Otherwise, I ignore lies, I ignore insults, I ignore all that. And then I will also tell you, each and every one of the minuscule complaints that have been thrown at me, I've seen some that are 1 line, some that are 2 lines. Apart from being false, I don't know what it is that I'm supposed to have done. But a narrative was being created that I am of short temperament. So I'm coming now to you as the JSC.
JSC, Supreme Court, Judiciary, and NCAJ particularly, those key offices.
So which one do you want me to start with in order of hierarchy? Let's start with the Supreme Court. I understand, and I've been listening to some of the questions asked about the Supreme Court. How would I bring collegiality? How will I bring a working relationship? I must tell you, Commissioner, that I am very good at that. I go the extra mile. When I want to bring harmony into a situation, I make the phone calls until I get the audience. I make the phone calls until people sit together. I have been instrumental in providing support for several legal groups, and including the Senior Counsel Bar, and I'm sure almost all of them will say that I'm a team builder. I pull people. I call them. I call somebody 20 times if I have to. So in the case of the Supreme Court, I know I am acquainted with all of those learned and very, very senior and eminently qualified individuals who serve on that bench. And if at all there is collegiality that is not, or the collegiality is not at the required level, I see myself as the right person to bring everyone to the table, working together, agreeing to disagree in a civil manner, so that the best jurisprudence comes out of that court. I delegate a lot. I delegate a lot in the sense that as soon as I got to the DPP's office as DPP, I dispersed my authority. I created sections and departments and allowed people to run with them and report to me only when they had to. So it's not, for me, empire building is not a trait I have. So that I consider, even though first in line, I consider that the smallest of the problems. The JSC is a bigger problem. The 9, 10 of you, or 11 when you finally become 11, are all appointed from big places, elected by powerful institutions, have offices in your own right, like the Honorable the Attorney General, and I can't come and dictate to you. I will have to build consensus around most issues. I have no qualms about being the big man and having to do it my way. If you ask me that, I often wondered why, when the Honorable former Chief Justice who had complaints to make to the President or to the public, directed at the public, he stood on those steps alone. I often wondered where was Commissioner Macharia Njeru and team. What am I saying? My approach would be, we all as a commission have to agree, or by way of majority, have to agree that we have a problem, and then we would address, if we had to, address the public on that subject together. I believe that is the only way for an institution such as yours. In addition, and now that you ask, I even am aware that there is litigation between some of you. Priority, why does it have to be there? I think those are the things that have to be attended. We must stop this. We must speak with one voice, even when we disagree. So for me, it's a priority area. Nothing can be done without a supportive JSC. Nothing can be done without each one of the JSC members feeling appreciated and whatever. And to make this happen, count on me. I will call you 20 times, even if you are angry and you don't want to speak to somebody else. I will make you come to the table. So for me, that is easy. The NCAJ, National Council of Administration of Justice, I have worked with every one of those. There's quite a huge stakeholder list. So the ones in government, meaning the police, the DPP, the prisons, the probation office, and all those, even the LSK, and all of those, we will work as a team. For me, it's a question of winning, and it's not empire building, it's not having the big car on the block, it's not about trappings of power. I've had those things, they don't mean much to me. In fact, even when I was there, I didn't consider them much. My life didn't change at all.
Okay. I wish you well.
Thank you.
Thank you, Commissioner Jero. I will now request Honorable Commissioner, the Attorney General, to ask his question.
Thank you very much, Honorable Madam Chair. Good afternoon, Senior Counsel.
Good afternoon, Commissioner.
We will continue from where Honorable Commissioner Macharia left off. You've likened the judiciary to a sinking ship.
Pardon me, stuck ship.
Stuck ship.
Yes.
Thank you for the correction. And you have also identified various areas where you consider there is a crisis in the judiciary. And amongst them is the inadequacy of service delivery, the absence or the decline in confidence, leadership you mentioned, specifically vis-a-vis the executive. You mentioned the cartels and the brokers. So you have identified the problem. What you haven't told us specifically, in the event that your prayer is answered and you're now the Chief Justice and you have walked up the steps you keep referring to, Just take 3 areas out of the list that you have enunciated upon and tell us specifically what steps, for instance, practical steps would you take to remove the cartels that you have alluded to bring about. You've mentioned collaboration with the executive and other stakeholders, but you haven't told us the recipe you're going to use. You've mentioned making telephone calls, but how are you going to solve this crisis? Telephone calls may not do it. Over to you, Senior Counsel.
Thank you very much, Honorable the Attorney General, Commissioner. Let's start with cartels, this insidious group or grouping that we talk about year in, year out. Again, I go back to my time as the DPP. Cartels move on when they can no longer feed and feast. So just the fact that the honeymoon is over, they are the first to know. But should they not move on? And I can tell you, and I will not state their names for the record here, they are known. So they will, through EACC and any other agency, be placed under a spotlight. And when the appropriate evidence is found, action will be taken. So, that is the easier part. Of course, they'll fight back and they'll call us names on social media, but we can live with that. Practical steps, talking about resources and everything else, telephone calls. My Lord, you've challenged me. Without resources, the judiciary cannot move. The ship is stuck. It's not broken. It's not leaking. It is not sinking. It simply needs to be unstuck. And it so happens the manner in which it is stuck can only be removed with, to begin with, the 2 issues that are no longer elephants in the room. They're the obvious things. Resolving the issue of the 41 judges and having a discussion about resources. Telephone call is a term of art. The last time I checked, it was a very good telephone in the Chief Justice's office that could reach very far. But that's not what will resolve the issue. In fact, it will probably be used to ask for an appointment. But I would make it even better. Were I to be recommended and finally appointed to the office of Chief Justice, I will not leave State House until I've had a fair discussion on these issues. So I'm not talking about 100 days. I will come within close proximity of the President of this Republic on the day I am sworn in, and that is when the discussion will start. And I appreciate I might not come home with the results that anybody or even I want, but that is a starting point. So for me, it is what is possible, what is achievable that I will do. So for me, Honorable Commissioner, it is simple. Maybe I go back to the question that Commissioner Macharia mentioned about insiders and outsiders. outsiders are entitled to some bad manners in terms of protocol, and they can break the protocol and have the discussion sooner rather than later. When you grow up within a regimented system, when you are in an institution such as this, where there appears to be a corporate position taken on the two subjects, and I can tell you that there appears to be, because as I have come for this interview, I have had one or two friends tell me, I hope you are not going to say you will have a discussion with the head of state. And I said, why do you say that? And they said, well, everybody else thinks it's the wrong thing. And I said, well, I make up my own mind. I decide that in my function, in my role as coordinating with other arms of government, I am entitled to make the call, even without the permission of the JSE. But on the final decisions, I'll bring it back to the table and we'll have a discussion with the JSE. So for me, maybe the situation, I'm misreading the situation, but I see a fairly simple way out of this. When it comes to funding, Commissioner Attorney General, we all know what's happening in the government. We all know their limited resources. I would like to go back a little to something that started when I was there, Vision 2030, which is the judiciary dovetails into Vision 2030, and there is an expectation by the year 2030, so much will have been done, with the judiciary having achieved so much. If those plans of Vision 2030 are adjustable, if the government's development programs can be what's the right word, compressed into 4 and only limited projects, it is unfair to imagine that the programs of the judiciary should not equally be affected. But, as has been said, what the judiciary takes is less than 1%. A case can be made for a little more.
Who would you engage
in on this matter?
Mm-hmm.
It would flow from the first discussion I have with the head of state, and I then expect and would request that he authorizes or directs the Treasury to engage us. And once that is done, it will flow, and finally we'll get to the Appropriations and Budgetary Committee in Parliament, who look at the estimates. But initially it is the Treasury at the highest level, that is the Cabinet Secretary and his Permanent Secretary.
And if you found that the Cabinet Secretary would not see you?
I would stick to the first, I would go back to number 1, meaning go down to number 2. If you don't, you go back to the head of state, because I believe he is the only person who can give direction on the subject of reallocation. Why do I say that? You look at the budget of the executive is a whopping, 95% of the entire revenue. So the only money that can be found or can be taken is from the executive. I have a little bit of experience with
Isn't that the function of the legislature?
What is this? The allocation?
Mm-hmm.
No. The legislature comes in when the estimates are done and the proposals are done. So you need to make your case first and get somebody to cede some of his or her money before it becomes a discussion for the legislature.
All right, let's leave that there so that we can give other commissioners a chance. You said you're familiar with the bungalow principles, and obviously...
maybe before you change the subject,
yes.
I just wanted to go somewhere else on the question of finance. As I stated before, Commissioner, I have some experience with working with donors. Given the time it has been since I was last in government, I wouldn't say I have networks at my fingertips. But when you look at my CV, at some point I was the contact person for visiting missions of the United Nations, World Bank, International Monetary Fund, and other multilateral agencies. to discuss legal matters and support. I directly participated in amending legislation. I think I was in the Attorney General in certain areas, anti-money laundering, anti-terrorism, and so on and so forth. But on the issue of, that is it. I was on the issue of funding. I managed to obtain donor funding from the USAID to operationalize a specialized prosecuting section to handle anti-corruption cases. Ultimately, that office became the office of the DPP. I also was able to get money from IDRC, which is the Canadian Development Agency, to develop a national prosecution policy and a prosecutor's manual. What I'm trying to say is, in the event that we don't get the funding gap sorted out by the government, I believe I still have, I'm not too old to run around, I still have the ability to convince the donors that the judiciary is serious, and I give my guarantee as CJ that the funds will be properly utilized.
Would that put you in a position of conflict vis-a-vis the independence of the judiciary?
I would carefully look at the agencies. The question was, I think, asked and answered in a previous interview. I wouldn't go for public-private partnerships. I would go for publicly owned multilateral agencies where there is no quid pro quo expected. I have a bit of exposure to the question of conflict. When the Milimani Commercial Court was first created, I was working for Central Bank as one of its lawyers, and the Central Bank came up with money to completely fund the smaller commercial Milimani Court. And there was that question and that objection, because there was at the same time the Goldenberg prosecutions, and the people on the receiving end of the Goldenberg prosecutions were suggesting that the complainant is now funding the judicial arm. So it's a question of care. UNODC, IDLO, these are people who are already in, but all they want is shown the way. I'm saying this, Mr. Attorney General, because I look at the spending spree that has taken place. I don't use the word badly, but I use the word just to talk about the volumes. To build over 60 courts simultaneously, it's just, I mean, it was a gamble. And so what you have all the courts at 80-90% complete, but none complete. So we now need to rationalize and plan a little better on completing them in batches. So, you know, who knows, the only option might be the donors.
Thank you. How independent would you say the judges are currently, and the judiciary at large?
I would say there is independence. I would, you want to, how do you want to describe it, in percentages, or want you? I think there is. I think, as a general statement, there is independence.
And how would you, as Chief Justice, enhance that?
The question of independence is not the issue. As I see it, there is this discussion of, there is this idea that if anyone were to speak or to have a discussion with the executive or the head of state regarding certain matters, it is compromising the independence of the judiciary. I take the view that you can speak, you can be interdependent, you can interrelate with the executive without compromising your independence. But it depends. You need to look at who you're dealing with. You need to look at the character. And I'm not talking about on the side of the executive. The judiciary needs a person who they trust will deal with the matter without having to compromise on independence.
I see. Now, you mentioned that you were a member of the National Steering Committee on
I was.
the fight against corruption. And I'm sure you're aware of the numerous pending cases on corruption which are still pending in the judiciary. The Goldenberg one, which started in 1993, I believe some aspects of it are still in the books. You're now Chief Justice. You alluded to bringing together the stakeholders in terms of collaboration. What are you bringing to the table to ensure that there is expedient resolution of matters corruption in the judiciary?
What comes to my mind, Commissioner Attorney General, was a televised meeting at State House where you attended, and the other agencies concerned with fighting corruption. You attended on behalf of the judiciary, and the other agencies were also represented. And I recall vividly the statement made by the President when he said, "I've done my part. Where are the results?" And, you know, basically saying he had done his part. I therefore, on that, say that it's a question of re-examining the interplay with those agencies that are concerned with investigating, prosecuting, and adjudicating on corruption cases. For far too long, has this blame game gone on. And today I want to speak for the judiciary. In my view, the time for blaming the judiciary in that blame game has never come to pass. I believe that the responsibility is still, or the failures are still with the investigation and the prosecutions. And it is only when enough of those cases have gone through the system that you can apportion some blame to the judiciary. So having said that, the three agencies need to sit down again and stop blaming each other and agree, not to convict, but agree that everybody takes their responsibilities a little more seriously. As a defense counsel, and this comes into play, I have been in cases where cases end up in court and the prosecution is not ready for months, years, and when the big stick comes around as to who is to blame, the judiciary gets hit by it. So that discussion needs to be had in the at the interministerial or head of three arms situation, had three branches of government again. But it's simply something that needs to be revisited. Otherwise, I can see all the targets that were provided a couple of years ago have come and passed.
Thank you, Senior Counsel. But that's only one aspect of it. What about the cases which are actually in the judiciary? Some half done, a quarter done, and they're stuck. You're now the Chief Justice.
On my part, as far as the Chief Justice is concerned, the only person I can call up and get a brief from is the magistrate handling the matter. And I'm not asking him to make up his mind in one way or the other, but I will say, give me a report on this case from A to Z. And you, from that report, as Chief Justice, will be able to see how many times the judiciary failed, how many times the prosecution failed, how many times the investigating officer failed. And when he is not in the room, these are discussions you then have with your counterparts.
So you have perused the report and you can see that the default is on the part of the judiciary in that particular cluster of cases.
Then the action can be taken. If that particular officer is not capable of managing that portfolio, then he might as well move to a different station.
Thank you very much, Senior Counsel. That will be all.
And give him some light duties elsewhere.
Thank you. Thank you, Chair.
Thank you, the Attorney General. I now request Commissioner Gishohi to please ask your questions.
Thank you, Chair. Good afternoon, Council.
Good afternoon, Commissioner.
I'll be brief because most of the issues that I would have raised have been raised. But I have one question. In case you get this position of a Chief Justice, I would like you to enlighten us on how you'd be able to approach that matter. I've also seen from your report here that you are a member of the International Center for Settlement of Investment Dispute.
Yes.
2012-2018. There has been general concern about investment disputes within our commercial codes and tax codes, and also the issue of small court claims court, particularly relates to the small micro enterprises. If you are to get this position as Chief Justice, could you maybe share with us the framework that you will put in place to ensure that you can be able to open up this system so that you can be able to have this money flow to the economy, particularly on commercial codes and the tax code and the small code, claims code?
Thank you, Commissioner. As I see it from where I sit, more and more judicial officers may not be the solution. I think we see that the number, despite the number of judicial officers we are appointing, the backlog is still piling up, more than correspondingly, meaning it's just something. So it must mean that there's something we're not doing right. And it must mean there must be another way of doing this so that the commercial disputes, and in particular the small claims that affect the small micro enterprises, is freed up faster. And I see technology, I see digitization being the way forward.
ICT?
ICT.
In what form?
Just the pilot, I have examined the write-ups on the pilot projects. They're all good. But like the one in the commercial court, it is a pilot project. What I'm saying is it hasn't been rolled out. So we need to roll out these systems so that the entire process, end to end, is within the program.
Okay.
So other countries have done this and they've changed their economy. But having more and more officers doesn't seem to correspondingly reduce, one, the backlog, and end these cases. The other thing that I would really emphasize on is more and more court-appointed mediation. I noticed from the write-ups that just by introducing and operationalizing court-appointed mediation, the ease of doing business in Kenya, the standing of Kenya went up. It really helped everything. And court-appointed mediation is a phenomenal thing. Okay. Because you are talking about two obstinate people who don't want to concede that they are wrong. But as soon as you clothe mediation with the authority of the court, they then, relax a little, and they compromise on these claims and they shake hands. And if there are payments to be made, they are released and so on. So, these are the things that should be promoted.
Honorable Counsel, one of the concerns is that we concentrate so much within Nairobi, forgetting that 80% of our people in the rural areas have these issues and they need them resolved. If you get the position as Chief Justice, we want to have an idea, what time frame would you be able to have these things in place? I've been here for 1 year, for 2 years, it's the same thing.
Now, Honorable Commissioner, you've been here for 3 years and we're still talking about the same thing.
Yes.
And my respectful view about an insider would be that after 5 years you'd still be talking about the same thing. Why? Because it's not, I don't mean any disrespect, but you're tired, you're doing things, they're not working, and you can't think out of the box. person who is objective, engages in critical thinking, answer that question. That's a very good question. I will ask them, why haven't you? And why can't we do it in a month?
Okay.
And I will get the answer. And if it is possible, it will be done.
Okay.
But one of the things I propose to do, as soon as, or in the event that I was appointed, is actually tour all the court systems in the country. And when I say tour, I don't mean photo sessions. Really find out what the problems are.
Okay.
Yeah.
Now let me go to my area. That was just by the way. I want to focus into the commission, GSE. You are the chairperson of the commission. Very candidly and very openly, in your view, what is ailing us as a commission? One thing that is ailing us as a commission that you will be able to address for us to move from the comfort zone.
One thing that is ailing the commission, from the outside, and I will correct myself when I come inside, I think there's too much sitting.
Too much sitting.
With the attendant consequences on finance.
Yeah. So what would you do?
Sit less, be more effective in what we're doing, and revert back to being you're almost a full-time commission.
Okay.
You shouldn't be as full-time.
Okay. There is this saying.
The other thing I would do,
Yes.
this is just a view I hold and subject to correction. The process of attending to complaints
Oh yes.
can be expedited by being more aggressive on complaints that are touching on criticisms about a decision when matters are one pending in court, or the right remedy would be an appeal. So be a little more aggressive in pushing them back. That way you won't have so many complaints, and you can spend your time dealing with the very serious complaints of serious misconduct and proven corruption or establishable corruption, etc., etc.
Okay. I want to address the issue of the human resource, which is very critical, as you said. And also, looking at the issues, I think I looked at your CV, there's a quotation I got there. Efficiency is the cornerstone of an organization.
Yes.
Efficiency is a cornerstone of the organization.
Yes.
On the issue of staff, not the judicial officers, staff themselves. How would you, question is how, two things would you do to make sure that you increase efficiency on part of the staff?
It's a good question, Mr. Commissioner. I would, for example, when I read the strategic plan, I read the state of the judiciary reports, there is this fixation about is it called the establishment being 9,000 plus. That is what is there. And then there are only 4,000 or 5,000 people, and therefore there's a shortfall of so many staff. It looks like, yes, somebody is not helping you or somebody is not doing you, but when you're doing things in a certain way and somehow the output is not what you expect, it is perhaps time to look at how much more you can get from those who serve before you focus on that. I mean, I heard, we all listened to the interviews, it arose in another one where I remember that it was the first gentleman, my brother, who said, why have a 4- or 5-story building in a place where there's no activity? There's no need for that court. So what you have done is you have built the court, now you have to justify it. So you're now looking for staff to fill it, but yet there is no activity to warrant the existence of that court. So from my reading of all these reports, experts abound to advise, but you need to change the approach in advising these in seeking opinions of these experts. Stop asking them, how do we grow into the biggest and the hugest and this and that? Just start asking them, how can we now maximize with what we have, then grow progressively.
Okay. We have various directorates within the commission.
Yes,
And we have our secretary who is more or less the CEO.
yes.
I want to pick on you in terms of your management, how you are going to ensure that those directorates, human resource, financial departments, procurement department, you as a chairperson of the commission, how will you be able to ensure that they produce? How do you relate with them as a chairperson of the commission?
I'm the chairperson of the commission. We start by accepting that it hasn't worked, or it hasn't worked as well as we expect.
Yes.
And so we ask them now to justify the way forward, or admit that perhaps the best plans have not been the ones, the best planning, and then reorganize it all.
Okay.
In other words, stop digging a hole. You're in a hole. Get out. And it's only an outsider who can come and say, why are we still digging? Why are we still trying to finish a 5-story building? And there are no judges and magistrates for that place.
You talked about this work management by working around.
Yes.
Can you be able to take it up a little bit in terms of the ICT that we have
Yes.
across the Republic?
Yes.
And try to see how you can maximize the ICT to ensure that this management approach of yours is able to produce the results.
I would do exactly that. I mean, I would walk about, I would visit, I would talk to the operator, and I would talk to the user, user being, of course, the judicial staff and also the advocates. Because I think in several court stations there's equipment, but it's not being used.
Okay.
Yes.
My next look is devolution in this country. What do you see the role of the place of judiciary in terms of devolution?
Devolution is a wonderful, there's a word I'm looking for. It's a wonderful, it's not a benchmark, but it's a wonderful rolling, what is it called? Not milestone, but it should be the basis for rolling out the judiciary. It should be the system that we use to ensure that we cover the country. So as the rest of government devolves, the court, and it has, to the credit of the judiciary, that has been by and large achieved.
Okay.
But I think what hasn't been achieved is ensuring that what is happening in, let's say, Milimani is happening in every county, main county court.
I wanted you to focus on access of justice.
Yes.
And in 2016, I happened to have been in Meru, where there was a conference for devolution, and one of the persons who was addressing that conference was the Honorable Chief Justice Mutunga. And he talked that judiciary has a lot of opportunities to increase this access of justice if you can be able to collaborate with the county governments. Now, that's where I want you to address yourself.
I was hoping that's what you're asking, but I will answer it. I thought about it the other day, and I said it looks very easy to require the courts the county governments to pick up some of the bills, like, for example, putting up the physical infrastructure. It is the best way of getting about it. But I think in most counties, headquarters, the most cases against the public would probably be against the county government. So you don't want to owe too much to the county government. There might be a formula of doing it, where that debt is not created. When I say debt of gratitude, if a governor, a certain administration in the county were to put up a court for you, and then every day he is the one being sued, you would find it very difficult to be entering judgment against him. But there might be another way of doing it where the deduction for the purposes of such construction is probably deducted at source, but in the name of the county. But it's something to think about.
Yeah, but council, if you look at CDF, they have built courts all over.
I'm mindful of that. I'm mindful of that. It's a good way of doing it, but when the county is one of the principal litigants in a court in a small town,
Okay. The other issue is still the commission, and you are the chairperson, the issue of inclusivity, which the Constitution is very, very clear about it, making sure that you are inclusive in terms of the staff, in your recruitment, in your promotion, in all the decisions that you make. Could you share with us your thoughts as chairperson of the commission, how you'll be able to make in practical terms and not in theory, that the judiciary remains inclusive to all Kenyans in terms of opportunities for employment, for promotion, for training, those lines?
Thank you very much, Mr. Commissioner. I am a firm believer in inclusivity. I believe the biggest scourge we have in this country is tribalism, and it creates all the instability we've ever had. Now, whilst it is not our place to discuss the other arms of government, it is our place to discuss what happens in the JSC and the judiciary. I take the view, and I will advocate for it, that there must be inclusivity. And there must be no domination whatsoever by any single ethnic group in a disproportionate manner. I qualify that, in a disproportionate manner, in the JSC or in the judiciary.
Okay.
So much so that when we are dealing with the courts, at every level of the court system, the courts must reflect the face of Kenya.
Okay.
So that when you are dealing with the apex court, which is the Supreme Court, it must reflect regional balance as far as is possible.
My two final questions.
And permit me to close it by saying, and at the very minimum, the 2/3 gender rule must be applied.
Okay. My two last questions. Communication in terms of a communication strategy. You talked about the stairs, talked about other issues. I would like to hear from you. If you become the chairperson of the commission and also Chief Justice, what kind of communication strategy will you be able to approach to ensure that you communicate and your case are understood by Kenyans and the other arms of government?
The first point I want to make is that the Chief Justice is the face of the judiciary.
Okay.
And he ought to be and should be a very good communicator, because every time he opens his mouth, he will be quoted, it shall be reported. But behind him, he must have a very good communications team that not only broadcasts what he says, but advises him on what is appropriate in so many circumstances. But it must be robust. It must be robust. That is what makes people feel that the courts exist, the courts are independent, the courts are credible, the courts are taking care of Wananchi's interest. So it must be robust.
Okay. My final question, Chair, Honorable Council. I was reading some of the write-ups you have here, and one of your referees refers to a very good team worker, a thinker for that matter. And you also, in your earlier remarks, you talked about being identified as blue-eyed boy for 2 years. And within the second year, you're out. And you have a big team that was working with you. What happened? How do I want to consult to have the two combined?
Blue-eyed boy, I should explain it. We come into office in 2003, and the platform upon which the then government, the NAC government, came into power was anti-corruption. So individuals like me were in high demand, who had a track record and who were seen to be credible. I might mention a colleague of mine at the time, John Gidongo. And so we are busy working day and night, trying to seal loopholes, trying to work on cases, trying to investigate matters or cause them to be investigated. But by the second year, the same government, the files we are reading are the files of ministers in that government. So suddenly everyone starts whispering when they see us, and me, because here is the prosecutor.
No, Council, let's not talk about personalities.
No, I'm not talking about personalities.
Yes.
I'm talking about how I cease to be the blue-eyed boy, because the agenda has changed. Correct? The agenda has changed. Now, perhaps
You are no longer part of the team.
not part of the team. I am not covering up.
Thank you, Chair. Thank you, Council.
Thank you for the question.
Thank you very
But
much.
I should finish the question, the answer. And when I ceased to be the blue-eyed boy, I was shown the door.
Thank you, Commissioner Agishohi. Thank you, Senior Counsel. Lastly, I now ask Commissioner Evelyn Orwande to ask the...
Chair.
Oh, sorry, Commissioner Koskei.
Oh,
Thank you,
Go
Chair.
ahead, yeah.
Good afternoon, Senior Counsel.
good afternoon.
Yeah, I have 2-3 questions. One, I hope you agree with me that they say that the future activities is informed by the past activities, and that whatever you do or you want to do, you reflect on the past. So I want you to tell this commission the happenings in the last 10 years, either political, either economic, or legal, the happenings that will inform your administration as a Chief Justice, that will shape the direction of your administration and influence. 2, 3, or 4.
Thank you very much, Commissioner Koskei. Very wide question with very limited time, but I'll try and pick on one thing or two that has general application. Where are we coming from as far as the administration of justice is concerned? We took the credibility of the judiciary for granted, to the point where, and we took it for granted and carried on doing our own things because we were in our safe zones until 2007, when we woke up to a disputed election and we woke up to extreme violence. The transformation, the first report, records that as a fact, that it was because no one had any faith in the judiciary, and that's why they turned upon each other with hammer and tongs and pangas and arrows. That is our history. We then had a new constitution. Well, we had many commissions, and the result of the commissions gave rise to the birth of Constitution 2010. And within the Constitution 2010, we had this wonderful space for the judiciary. We must never let ourselves slip back to a judiciary that nobody cares for, nobody believes in. We must not let anybody ever say, why should I bother going to court? I know the result. We must keep the credibility of the judiciary intact. We must ensure its independence, But that is not to say we can't talk to each other. Everybody wants a progressive country. Everybody wants a wonderful country. And if I were ever, and I hope I will, sit with President Kenyatta on this issue, I would say to him, for the security of everything else you have done, for example, the infrastructure, for it all to work, you need a credible justice system. Otherwise, in a country that has anarchy, nothing works. The 95% even of his budget is useless for the purposes of the executive. So I don't have to get this job. I don't want to sound arrogant. It's a privilege to serve. It's an honor to serve. I feel that you can use my services, but it means nothing to me if I don't get it. But I want that for posterity, for the practice of law, for our children. That is the one thing I would say. Our history should inform everything we do for our future.
Thank you. My second question is, there's an article on today's, one of the dailies, and even you have alluded to, ease of doing business. And it says, a country's choice of chief justice goes beyond picking a manager to run its judicial bureaucracy. It has far-reaching ramifications on the country's ease of doing business. And that is why the Judicial Service Commission ought to play its cards right in picking David Maraga's successor. Do you agree, and why?
In an economy like ours, first of all, I agree, 100%. And it wasn't directed at me. That message was directed at you and your colleagues. You get it wrong. Before you find out that you are wrong, it will be 5 years down the line. Investments will have moved. Amongst so many other things, you will never pick up again, because the whole region and the whole continent is now awake. When we came up with Vision 2030, it might have been the first such program that people are discussing, but within months, years, every country in the region is chasing the same investment, chasing the same targets. So the responsibility on the part of the JSE is think beyond the normal things. See the bigger picture, see where we would all like Kenya to be in 10 years.
Yes, I want you to tell us, do you fit the description here on ease of doing business? And can you give us 3, 4, 5 attributes that you have that will be assured that when you come in here, ease of doing business in this country, in as far as judicial, work is concerned, will be different in terms of the economic growth?
Business as a group, or investments as a category, have the greatest fears they have in an economy in which to invest are corruption and delays. And depending on how you look at them, they are one and the same thing. Systems that have huge delays are often corrupt. Now, you remember I mentioned about cartels. It is actually the cartels that hurt investment the most, because those cartels don't operate on the Mamamboga cases. They operate on the multi-billion-dollar cases, the big cases. And all you need to do is create a situation where a big investor gets, for lack of a better word, double-crossed by the system. He loses his investment, or he's robbed of his investment. And he can see, 1 + 1 is 2. But in this case, the judge has gone out of his way to turn it on its head. All that happens is he tells everybody else, and people move on. Onagishoyi mentioned the organization where I was a member, the ICSID, International Center for the Investments of Disputes, which is a World Bank investment dispute settlement center.
Yes.
I was a member for a few years. And what then happens is these investors don't trust our courts anymore. They go to international tribunals. And you're going to find more and more all these investment clauses indicate that in the event of a dispute, arbitration is in London, in the US, in Hong Kong, and I've even seen where there are Chinese investors, arbitration will be in Peking or in Beijing.
Okay.
So, to answer your question, I believe I would inspire the confidence required in the business community.
So you will introduce those best practices.
I will absolutely.
Within the judicial system to ensure that cases are moved faster. There is alternative dispute resolution systems that may not necessarily take years to. That's what I think you are saying.
That's what I'll focus on.
Now, let us go to corruption, and the Attorney General asked your question around it. You see, corruption has become a menace in this country, and it's so contentious that there is no institution that wants to own up and say, we are going to fight our side, you fight yours. To the extent now that you get institutions, especially executives, saying, judiciary is the weakest link. Other quarters say, judiciary cannot be the weakest link because judiciary is not in the sequence of corruption. When the real act of corruption is being done, they are not there. They are only coming in to listen to the accused and the accuser and make a determination. And this is as a result of a theory called the weakest link theory, which says this concept is states like this. It holds that each action in a sequence is dependent upon the performance of the action that comes before it. So, your thoughts on this? Is judiciary the weakest link, or it is being bastardized for the inefficiencies of the other agencies?
First of all, I want to paraphrase the saying. The one I know is a chain is only as strong as its weakest link. And in this regard, I recall the words of the president whenever he was on this subject. And he simply was tired of the blame game. And he was saying, I'm tired, I have facilitated all the sections, get on with your work, do your job. On my part, I would like to say the judiciary comes last in the chain. So if the weakest link is before it, it's not the weakest link. Until the case is heard and determined, then we can judge the judiciary. So I have to remind myself as you ask me that question, which hat I'm wearing, because some words very easily come out of my mouth because I've been the DPP, so my answer would have been slightly different. But for my part right now as the judiciary, I have no reason to think the judiciary is the weakest link, except to ask a question that the Honorable Attorney General asked. Audit the progression of all cases and determine whether or not the fault is actually on the part of the judiciary, not blanket condemnation.
My final question is on now the management of the institution. And senior counsel, there are statutes that are used for day-to-day running of the institution. One, in public institutions, I mean. One is Public Audits Act, the other one is Public Procurement and Disposals Act, the other one is Employments Act, PFM Act, etc. Let us go to procurement law, which I saw you even went to Rome for some training some time back, though it is a long time ago. But as a practicing lawyer, you must have been coming across a lot of corruption cases in procurement, so many things. There is a lot of writings, complaints in the newspapers and the rest, that the procurement is a problem. Now, we have a law which Exchequer and Audit Act 2001 was amended to create a procedure for procurement processes. And then a procurement law in 2005 was enacted, which later on was superseded by 2015. And this procurement law has some objectives that are very clear: value for money, transparency, accountability. You have to do procurement in a corporate manner. In your experience as a lawyer and also a Kenyan here, has this law really met its objectives? And to you, what are the limitations of this law?
Now, thank you, Commissioner. First of all, I'll go on to add that in my master's, I also did a paper on procurement and public accounting law.
Yeah.
So not only the course
Oh,
a long time ago. But having said that, I can only identify with what the head of government has said, which is the president. The country isn't getting value for whatever it buys or what the services are rendered. I can only say that because he is right there, he's watching it, he's getting all his reports. From where I'm sitting, I tend to agree. Our landscape is replete with stories about overpriced projects, and some of which don't even get off the ground. They are white elephants wherever they are. So that is in the public domain. That problem is something that needs to be looked at by another section of government. But in the case of the judiciary, when the time is appropriate and cases are brought to the judiciary, we will ensure that the magistrates also have some refresher courses on this aspect of the law, so that they stand a little wiser as they listen to these cases. It's fairly technical.
Yeah.
Everybody seems, when you listen to one person, he seems to be right. When you listen to the next one, he also seems to be right.
Thank you very much. My last perhaps question, not a question actually, I want your comment. You see, you asked a question on your management style, leadership style. You said you are Democrats. Okay. But out there, people say Philip Murgor is a maverick. He is a go-getter. You can't stand on his way. If you stand on his way, you go down as he's moving to meet his objective. All those around it. What do you say? Because they say when you're in a scene, you can't walk out without putting a fight. You have to win. What do you say about that?
I want to win the war on transformation. Any other questions? That was on a light note. Let me answer you a little more elaborately. The last thing you want in the office of the Chief Justice is a person who is not a go-getter. The last thing you want is a person who is not a maverick. And the last thing you want is a person who doesn't want to win everything that he gets into. So this institution needs a leader. But that leader has to have certain styles. And you need to only look at what I've achieved to know that it's never been alone. I work as a team. And in the case of the JSC, I'm one of those, if your ideas are good, I just go with them. It will not be something we argue about. Why should I argue about it? All these things come about when somebody becomes a nepotist, a tribalist, and his ears close because he doesn't want to hear you saying anything about the person who he has put in office, the person who enjoys his favor. For me, my mind is open. We're here to do a job. I might be relatively young in terms of the position, but I think you need the energy that is required to get this ship back sailing along the Suez Canal.
Thank you, Senior Counsel. Thank you, Chair.
Thank you, Commissioner Koskei. Commissioner Evelyn Orwade.
Thank you very much, Chair. Senior Counsel, I know I come at the tail end of the session.
We are all
So
tired.
some of the questions I may have may be touching on issues we've already touched, but there are certain perspectives I still need to assess. So please be patient, even if I seem to be revisiting what we've already touched on. You mentioned that you read the memorandum that was submitted by KMGA, which I think is commendable, because even though you're an outsider, you took your time to acquaint yourself with the issues that are on the table. From what I hear from you, you have had a fairly good assessment of one of the main concerns that the membership has about being left behind. You have mentioned in passing that what you intend to do to many of the concerns is to get out there, visit stations, and get to hear what the real problem is. But just like I said, you have a fair understanding of what at least one of the major issues is. So I just want to hear from you what practical steps you intend to take to address especially that major concern that you have highlighted.
Could you remind me which one? I mentioned several.
You said there is a concern that the junior employees, the magistrates, the cadres, the staff are left behind. I remember you used the word neglected, though you qualified it.
Mm-hmm.
Yes.
They've been left behind.
Yes.
You see, when I look at it, at paragraph 11, the memo says, from past leaderships, we want a Chief Justice who can demonstrate he or she does not promote cronyism, nepotism, or tribalism in employment or promotions. You are suggesting, you are stating that somewhere in the past, that was a problem. With the support of the JSC, if they themselves don't have an interest in that matter, that is quite an easy matter to attend to. I mean, it's all about looking at who exists and who doesn't exist within the system. Looking also at persons appointed in particular positions over everybody else, and so on. We'll examine all these. If I were to join as the Chief Justice and following this interview and what I'm saying now, how Kenyans react to this situation is I will be challenged. I will get memoranda of please examine this, please examine that. If there is any merit in what has been said, we will examine it. First, I will examine it as a Chief Justice, but if it is a matter that requires to be brought before the Commission, it shall be brought. And I will take a position. If it is wrong, I will take a position. If it can be sorted out, it will be sorted out. The other issue I mentioned was the issue of for the sake of survival of many young families in the judiciary, we want a Chief Justice who is family-centered and sensitive to judges, judicial officers, and judiciary staff who have young families and genuine challenges. Goes without saying.
Sorry, if I may interject, I am not talking about the many welfare issues that are there. I know we cannot have time to address all those.
Yes, which one was
There's a specific one you raised earlier that after you read the memorandum, what came to your mind is that there was a complaint or a general concern that in the previous regime, they were taken care of. They were part of the team. Subsequently, they feel like that they were left behind. And I remember you used the word neglected.
Yes.
In terms of cadre, not nepotism, not favoritism, but in terms of cadre, that they were left behind,
Yes.
or that they were neglected.
Yes.
And you said something about going around to get their concerns. And that's what I'm saying, you've already fairly appreciated that particular concern.
Yes.
So what practical steps do you intend to take to make sure the entire team, from the judge in the Supreme Court to the judicial staff in JSG1, all of them feel part of the team.
I will be available. I will visit them. I will have meetings with their representatives. Of course, I can't meet them all at the same time because they're in various stations. And where a case is made that they were neglected, appropriate action will be taken through the JSC.
Okay, let's move on. You've also
I'm actually looking for what was actually written, that some people had not moved in ranks for the last 4 years or something like that.
Okay, thank you. You fairly given your answer to that question.
Mm-hmm.
So if you can move on to the issue of the 41 judges, which you also mentioned in response to a question by my brother Commissioner, the Attorney General.
Mm-hmm.
And you said that you intend, if I understood you correctly, I stand to be corrected, you intend upon your swearing in to have a sitting at, I presume, the State House until at least you get an appointment. But when you went on explaining that, I got the impression you are also not very confident that that will work. So I just want to ask you, do you have any other strategy to seeing that this stalemate of the 41 judges is broken and we have them in office?
Let me go back a little. First of all, I said as early as the swearing in. So it means immediately. And in my respectful view, President Uhuru Kenyatta cannot refuse at a ceremony such as a swearing in to have a few minutes for the Chief Justice. But because that will not be the forum where there can be a detailed and a conclusive discussion, it will be followed, hopefully, by other meetings. Okay? So, you then went on to say that I don't sound hopeful. I believe very sincerely that the impasse, the deadlock can be broken. So I will pursue it on that basis until I hear, feel, or see otherwise. So I'm not going to approach it with the mind that it won't work. No, I'll approach it with the mind that I have every confidence that with goodwill on both sides, it shall be resolved. And again, I talk like the outsider. I don't have, there's a saying, when you have a vested interest in something, I don't have any skin in the game. I don't have a set or a judge or who I feel, is bothering me. That it should, no, I'm looking at it holistically. It's a it's a resource problem. It's affecting service delivery. We'll have that discussion.
Okay, thank you about that. My next question concerns the death penalty. Again, we had a discussion earlier on in the morning concerning the Muruatetu case and the racial danger in that case. The death penalty has come up for discussion in several cases in our superior courts, both in the Supreme Court and even in the Court of Appeal. And the discussion is majorly two-pronged. One is the constitutionality of the mandatory nature of the death sentence, and two, constitutionality of the death sentence itself. Now, in the context of the cases that have been handled in our courts, I would like to hear your perspective on the constitutionality of the death sentence.
It is constitutional. The law is quite clear. It is, and the Supreme Court left it as such, but it said making it mandatory is the problem.
What are your feelings about the death penalty itself and its treatment in our laws? Your personal feeling?
This is the area I would not like to go because it is obviously a matter that may be revisited, and I will be sitting on the bench, so we will leave it to that point in time.
Very well. The other question I have for you...
You may understand there are people who feel very strongly to retain it. There are those who feel very strongly that it shouldn't be in our statute books.
Exactly, and that is why I wanted to have a take on your own personal perspective.
And they will both, one day, if I sit on the Supreme Court, come before me. this meeting or this discussion should not come back to haunt me one way or the other.
You said, Mr. Senior Counsel, some of these questions that we are asking is basically to also get your perspective on certain issues that are of concern to the public, because the public is watching.
But I'm going to be a judge.
So you would rather withhold your
I'd
view?
rather withhold my view.
Okay, thank you very much. As a legal practitioner, have you ever had occasion to recuse yourself from a matter?
Many times.
And yeah, now that
Many
you say
times.
many times you've had that occasion, will you please just share with us the occasions and the reasons why you felt the need to recuse yourself? Or even in general, when counsel should consider recusing himself?
If I have acted for the party, if I'm, the party that I'm expected to sue, if I am on the panel of advocates for the institution, the issue, let me deal with it broadly. Whenever you feel that if you took a case, you internally will feel that you are conflicted, meaning you have two emotions regarding the case. You feel on the one hand you should be this way and that way. You should only act in a matter when it is clear you have no interest, that bothers you, and you should go forward. So I'm being general. The list of areas of conflict are limitless, and it depends on individual to individual. Yet, the universal thing is, if you look at it independently, what should you see?
Okay, thank you. My next question concerns the responsibility of a public officer. And the question I have for you is, under what circumstances can a public or state officer operate an account outside the borders of our country?
Shouldn't operate an account.
At all?
At all.
Thank you. Do you engage in community service of any
Yes,
kind?
I do, a lot.
Could you share with us some of the activities that you engage in?
Community service to me is something that in the African context happens every day. Let's start first with something that I might have put in my CV unless it was amended. I was involved in wildlife conservation for some years before my term ended. Community service, I always contribute to the schools and churches around my home area, and not only my home area. Anytime a call is made on me, I make my contribution. Just yesterday, a cancer patient made a request, so that's how I deal with it. But it's not something that I sit to think about and draw up on lists. I think that is not the purpose of community service. But I'm certainly a person who involves himself with community matters.
Okay, thank you. Moving on to your application, I looked at the documents that you filed. To start with, I think you've already shed some light on your appointment at the DPP. KRA did not clear you as tax compliant, and I believe they must have communicated to you the reasons why. All I want to hear from you is whether it has been sorted and whether you can now avail to us a document that clears you as tax compliant.
I have a tax compliance certificate until August of this year. So I met the requirements for the purposes of this interview. But following on I believe you're the ones who requested them for the information, they started engaging in issues which I thought amounted to some sort of blackmail, in terms of, you want to attend the interview, you must pay whatever we want. And I wrote to them, I said I will not submit to blackmail just because I want to serve the public in a certain capacity. I said, don't connect the two issues. I will attend my interview and I'll come back and have a discussion. So to answer your question, after my interview, I can listen to what it is they were saying, but I certainly rejected everything that they were coming up with because it was completely unsubstantiated and it was just leverage because of this interview.
So that is to say the matter is still unresolved?
I didn't go back. I will go back because I didn't want to be distracted from this interview. So I'll probably go back next week
Okay, thank you.
and communicate. But I told them to divorce the two issues. People who volunteer to serve the public or try and apply for jobs do not submit to blackmail, because at that point you're vulnerable and you want to get something done. I said, this is not a job I need to have, but I certainly wish to offer my services to the public.
Okay, that is noted. In the advertisement for the job, you also required to submit your audited accounts. Did you comply with that?
I believe I believe I did. I was dealing with it as a team, so you need to tell me if I didn't do anything. But anything that you required me to do, I believe I did.
You submitted audited accounts?
I believe I did.
Okay, we'll look at those.
Just let me know if there's any shortcomings. We did submit some accounts.
Okay. In the wealth declaration that you filed, Form 2B,
Yes.
you did not disclose whether you hold accounts and the money that you have in those accounts when you are declaring your assets. I noticed,
In personal accounts or?
yes, I noticed that I think either yesterday or the day before yesterday,
Yes.
you submitted a further declaration, including
Yes.
some property that you had left out,
Yes.
but you still have not included your bank accounts.
My personal bank account.
Yes, it's your
Okay.
personal wealth declaration.
I did submit my wealth declaration. My personal bank accounts, I'll check.
You submitted your wealth declaration form, isn't it?
I submitted
Together
a
with your
wealth declaration
application,
form.
together with the one for your
I've
spouse.
submitted audited accounts. I've submitted wealth declarations for my spouse. And as you rightly point out, there is an asset I acquired after applying for this interview. Applying for this interview, I declared it 2 days ago, and there is those assets which I declared, which are inheritance being processed. So the question of my personal bank account, I'll check. And if
I'm
I haven't-
focusing on the bank account. I'm saying you did not declare those. You did not list them amongst your assets. Is there a good reason why?
My accounts, I'll check.
Yes.
And I thought I did. I'll check. There's no reason for me not to. So you shall
Okay,
get it if you don't
if
have
you
it.
do not have a problem with that, then that's okay.
Yes, I will.
And if you intend to submit an updated one, then please remember to do that before we are done with the selection process.
You certainly will by Monday.
Thank you. Okay, now there are some, I don't want to call them complaints, but there is information we've also received from the public that I would like to share with you, and maybe here invite your comments. Some of the information that we've received, or let me say one of the complaints that we've received, concerns some succession cases that you handled on behalf of relatives, which are basically in the public domain. You agree they're in the public domain?
Yes, reported widely in the newspapers.
Thank you. So the allegations in those cases are that you are representing siblings against siblings, creating strife, bullying siblings out of property that maybe they ought to be to inherit. And basically our concerns from these complaints or from the information we received, they tend to point to the fact that you are not a consensus builder, you're not a team player, and also that you have problems delegating.
Go ahead.
That is the perception, at least I am getting. You're representing relatives in cases against relatives, and it's all creating very bad blood within the family. I don't know what you would say about that.
Have you read my response?
Yes, I did.
Okay. My response answers every single one of those false allegations comprehensively, but restrains itself from going too far because it is a matter pending in court and is due for hearing on the 22nd of April this month. But since you have asked, and you have asked on public TV, I have to respond. As I told you, I told the Commission, I always take a position when it comes to people who bully and who deprive people of what is theirs. So, in the case in question, these are cousins of mine, and what makes it impossible for somebody other than myself to represent them is because they found it impossible to get an advocate in the town that they live because of the nature of their brothers. No one wanted to touch their case. So it fell upon me. And the case is very simple. The deceased had plenty of property. He died intestate. The brothers, most of the brothers, took it upon themselves to take all the old man's property, led by the eldest son, who is a member of parliament, who took the lion's share. And they disinherited 15 sisters or girls and 5 widows. That was a case where I felt that I had to go beyond the call of normal duty. When it comes to what you say, consensus building, if you were to peruse the file that is before the Eldoret High Court, I have suggested 10, or many times, not 10, that it should go to court-appointed mediation, even in my absence. It went to court-appointed mediation, and what happened? The men stood on one side, the ladies stood on one side, and they were berated, insulted, bullied, and threatened till they were in tears and told, take nothing because it is what your father what your father wished. They left the mediation, we went back to court. So it is absolutely false that I am a bully, that I take anything from anyone, but I can plead guilty to something very small. I fight for justice. If they are my cousins, they are my sisters, I will fight for them. If those widows are there and they are destitute, landless, living hand to mouth today, except for the 10,000 we fought that they be given, I'm very proud of doing that, and they appreciate it. In fact, the mistreatment of the widows was so great that one mother died of neglect. We had to go to court and ask for a stipend of 10,000 shillings per month to be given to her for her upkeep and buying her nappies and all sorts of things. So it's a case where, and so that you will understand that your view has, or the facts have been considered, they applied for my disqualification before the Honorable Judge in Eldoret, and considering all the circumstances, Her Ladyship, the Judge in Eldoret, said there's no conflict of interest and there's nothing wrong that Mr. Murgor has done. So it's been considered. I wish to tell you this, Madam Commissioner. What would they like most? They would like to take everything from their sisters and mothers. If I become the Chief Justice, perhaps I won't be in that case, but somebody else may step into my shoes and fight as hard. So it's unfortunate, it's painful to have to talk about them in this manner, but since they are the ones who put out the complaint and circulated it widely on social media, I have to respond. So it's not something that I have any regrets about. So take it, not that I'm a bully, but take it that I take the side of victims. I'll fight for a woman, I'll fight for a widow, I'll fight for a girl anytime, for free.
Thank you. Maybe still on that same question arising from your answer, you've made a very passionate response to the question that I asked, and I can see it actually touches you deeply. But I just want a reassurance from you, and also maybe to the people concerned, that if you become Chief Justice, they will have nothing to fear concerning interference with that case or influence.
That is a fair position to take. I certainly give my professional and very personal undertaking that I wouldn't interfere with it, nor do I stoop to the level of doing things like that. All that these people deserve is a fair hearing, both sides, those who say they inherited everything and those who say they inherited nothing. These young men, well, they are not young, they're old men, say that the law of Kenya does not apply to them. Only something that Mr. Koskei might know, Bwana Koskei might know of. It's called KU customary law, where ladies and widows are subhuman, but they should come to the 21st century.
Thank you. Enough said about that particular complaint.
Okay, thank you.
The other complaint, maybe I can combine them. The other complaint, two other complaints that we've received raise concerns that you are likely to abuse office and that you may not have the ability to deal with complaints or disciplinary issues concerning magistrates and judges should you become Chief Justice. Reason for the latter one is that you once refused to act as assisting counsel in a tribunal that was set up to investigate judges who were suspended, and one of the reasons you gave was that you did not believe, if that is those are my words, that it appeared that you did not have faith in a witness you were supposed to lead in that tribunal. And for the former, that you instituted a malicious case against Kamlesh Patni.
Let's, can we deal with one at a time?
Okay.
I want to respond. This complaint that you referred to is by Nelson Harvey. He has no understanding about what happened at the time. He has no facts. The first one that I resigned from.
You refused to participate in the tribunal here.
To investigate judges.
Yes.
He has no information, he has no understanding. All that Harvey was doing was trolling through whatever he could find to create a memorandum to come and embarrass me. If he was sincere and knew the facts, all he has to do is to go and find out what happened to the case of Justice Aganyanya, the late. He has living relatives in this judiciary. He can go and find that what happened makes me stand out as a person who will not condone injustice. What happened was, and have you read through the 2,000-page document? Because I want to refer you to a page.
Just give your response.
I have put in the radical surgery summary of cases against judges, and I have gone on to point out that that radical surgery that was conducted by Justice Ringera during the tenure of the late Justice Kisheru is a matter that will always be a dark chapter in the judiciary of this country. In that, what appeared to have happened is the judges were identified first and then the evidence looked for. So in many cases, some complaints were found. But in the case of the late Justice D.K. Aganyanya, I, as assisting counsel, asked for the file and said, where is the compilation of evidence, the kind of evidence that you will get in the JSC in the preliminary panel? And I was taken around in circles between Justice Ringera and Justice
Counsel, allow me to interject yet again. I see you want to go into the background of the matter and all. Like I had mentioned earlier, we have concerns raised by stakeholders, and I just want to hear your take on some of the concerns that have been raised. The concern here is, because you see, as Chief Justice, you'll be receiving complaints from people you've interacted with before and people you do not even know, concerning the people working under you. The reassurance that the concerned parties here want to get from you is that you will not have preconceived notions about certain complainants regarding complaints that have been raised from you. Just that.
Thank you. So I finished my answer. When it came to trying to find the evidence against Justice D.K. Aganyanya, the late Justice Gisheru and Ringera took me around in circles till I established that there was no such evidence. When it came time to compiling the evidence, I was told who was supposed to be the complainant, who had not yet recorded a statement, yet a report had been made to the president, which resulted in the suspension of the late Justice D.K. Aganyanya. I have no apologies in saying that at that point, I washed my hands over the process. So when somebody says, I would therefore walk away from a process that is irregular, faulty, he should be giving me a commendation, not criticizing me. That's what I have to say.
Thank you. Maybe we can move on to the next one. The next one touches on the case against, the murder case against Kamlesh Patni. And the concern here is that you have a propensity to abusing power.
Again, this is another false complaint by Harvey, the suspended president, who had no right at all to forward such a complaint in the name of the LSK. But having said that, I have attached correspondence. There has been no complaint regarding the same case by the accused of the day, Mr. Kamlesh Patni. There has been no complaint again by his lawyers. But it bears pointing out that this is a matter that created great concern on the part of the judge who heard that case and purported to make those remarks about the conduct of the prosecution. You will find in the correspondence I sent you, it turned out that several things happened that were very unusual. The late Justice Gisheru sent the trial judge on leave. The late Justice Gisheru then, without any notification, assigned the case to Justice Jesse Lesit, who was not on the criminal murder trial murder trial bench. The personal advocate of Justice Gisheru, Fred Ngatia Senior Counsel, on the same day appeared as defense counsel. And then what happened was the judge galloped the case like the world was ending. First of all, we expected her to simply notify us that the case would not proceed. She said it was going to proceed, and it then proceeded. And it got to a point where we had to have a talk in chambers, where in front of the defense, I said, Madam, if you have made up your mind, keep it to yourself, but wait until it is time to rule on the matter. When the matter, she then forced the prosecution to close its case without calling a vital witness who was abroad and who Interpol was about to bring. And in 7 days, delivered a ruling of no case to answer, the contentious ruling. I, at the time, was still the DPP. I went to the registrar of the criminal division, whose name was Julio Seco, and requested to peruse the file. When the file would not come out of the chambers of the judge. When it finally came, it came with an instruction that the DPP could not photocopy the handwritten proceedings, but could only peruse them. When the proceedings or the draft, the handwritten judgment was perused, it materially differed from the typed ruling. This matter was reported to the Chief Justice. No action was taken. This matter was reported to the judges, and vetting board, and there was a very interesting outcome, as a result of which there was a further complaint. So my answer to that question is that that judgment is impugned. It gave rise to complaints. I don't accept the accusations therein, and it was brought before this commission in bad faith.
Okay, thank you. We've noted your comments on that. There are some other complaints that we have received. Some of them touch on cases that are live, so I'll refrain from asking you about those. Some, I believe, have been served upon you. So whatever response you're going to give to the commission will be considered.
I would like, actually what my detractors in quotes have done, have circulated these widely on social media. I would love the opportunity to give a short answer to every complaint.
All the complaints that you
all the complaints, I see them on social media. I see them circulated by Harvey, and then the next day you send them to me.
There are some that we have seen your response and we didn't feel the need to raise with you. There are some that have been served on you. You are yet to give us a response.
I have responded to everything served on me, unless you served me today. I was served with one more yesterday. I also responded within 15 minutes.
Great, then the response will be considered. Thank you.
So, do I have the chance to clear my name?
Chair, I don't know if we still have time for that.
I will be very short.
I think let us give him a chance to clear himself.
So just summarize them and I will respond. Oh, you are, okay. The one I received yesterday from the commission was by one Dennis Kangete Itui. He makes a complaint that is very difficult to understand, as he complains against nearly 10 people, 10 advocates and lawyers. But the long and the short is that he writes to this commission on the 12th of April against seeking to complain against the Honorable Justice William Ouko and Philip Murgor. I would like to say that if at all I handled this Kenyan as a person complaining as the DPP, I have no recollection whatsoever, because I processed many such people, many of them in a week. I have another complaint here sent to me from a lady known as Catherine Isige against Philip Murgor. It is all lies, and she fronts for the wife of Ambassador Dennis Awori, Kenya's former ambassador to Japan, who is currently the chairman of Toyota Kenya. And I wish to point out that the lies in her complaint, that I am a bully in her neighborhood and I bulldozed her property or her nursery school, is all lies. She and her partners attempted to set up a nursery school in a neighborhood in which I live. The neighborhood complained. The county council came and stopped them. They persisted. Their employees were arrested, and at some point there was some damage to their gate. They went to court in Milimani Law Courts, miscellaneous number 63 of 2011, before the Honorable Justice Gidua. They sued Nairobi City Council. The neighbors joined as interested parties. I represented the neighborhood, and it was found that all the documents they had used to suggest that they had change of user and were entitled to develop that property were forgeries. So all she's doing is thinking this is the time to throw stones, and she's doing it. There is another case, yes, there's another case of, this one I was surprised the commission could send me. It looks like it's from a blogger, somebody called Charles Ogega, and he says, very short email to the commission, whatever, the complaint is not specific, no, he said, he says, how on earth, he's addressing it to JSC and Vetting Committee, how on earth does Murgor gain pass to vie for this post? Isn't he the one shrewd layer who tirelessly fought for Chomley in a case where the accused shot and killed a poor Kenyan guard in an attempt to hide his illegal game meat slaughtering? Please guard our justice system from evil characters who can't spare anyone in their spin of greed. Concerned Kenyan. And I was sent this to reply. How do I reply to this? But anyway, I did. And I have pointed out that the documents regarding the case of Chomley are to be found in my bundle at page 2089 and 2099. The long and the short of that issue is that it is the Honorable Attorney General at the time who ordered the termination of that case, and for good reason. And even if it was found that it was for bad reason, the Attorney General and the subsequent DPP had every right to reinstate it. They did not.
I'm getting a bit concerned. You said you're going to be very brief.
I'm finished, my last one. The case, and then there is the questionable memoranda sent by Nelson Andai Harvey to the commission. I am, with great respect to the commission, disappointed that that was forwarded to me, despite the fact that it was totally disowned by the Council of the Law Society.
Senior Counsel, I just need to bring it to your attention that as a commission, it is our obligation to receive whatever reports that are brought to us by whichever people, from whichever walk of life, or in whatever capacity. And we have that obligation to share that complaint with you. You cannot just trash and assume any complaint.
I'm actually not trashing it. I am recording my view, and I'm saying that I responded comprehensively on that complaint, and I asked the court to look at my considered complaint, including the reasons why Nelson Andai Harvey has malice for me. That's all.
We shall do that. Thank you. Thank you. Chair? Thank you.
Just one or two things I would like to mention. Actually, what Commissioner already meant is that we sent all the complaints to the candidates to be fair to them, and also to be fair to those people who sent. So it's not just you, Senior Counsel.
I thank you.
I have two clarifications for you to make. You kept saying, Senior Counsel, that this is not a job that you need to have. You have said that several times, and yet you have spent here the whole day, you tried to make a case. So maybe you can explain that?
Thank you very much. I'm sorry if it was misunderstood. There is two types of, maybe even more types of applicants who can apply for a job such as this. There are those who need the job. They need a salary. They need perhaps the trappings that go with the office, and they'll do anything to get it. There are those who, sitting in their professional space, are comfortable in what they do, but they see an opportunity to serve the country. I am one of the latter. So, need, I use the word need in that sense of saying, I will do anything to get it. I will not do anything to get it. I will attend before you. I will apply. I will give my best, and I will be honored to serve. So that is the distinction I make, and that's my answer.
Okay. The last clarification from me. You also said that as somebody from outside, you are better able to fix the problems of the judiciary if you come in.
Yes.
But my question is, isn't it also true that an insider who may also know the problems can also solve the problems?
Thank you for that question. And first of all, I want to clarify, I mean no disrespect to any of the other applicants who are insiders. In fact, I want to say that I listened to the interview of Her Ladyship Martha Koome, and I said to myself, at that point of the interviews, that is certainly a person who can do the job. So I don't mean it in a disrespectful way, but now as an objective outsider, critically looking at your problems, I do not see how you can dig yourself out of the hole. I say that again as a figure of speech. I see the fastest way out of this situation is to adopt the Willy Mutunga approach. Come in with a clean mind. When I say clean, I mean clear, and identify the problem and go to solve it. So that is the context with which I refer to insider, outsider.
Okay.
Yeah, but I don't mean that there is no one qualified. By the time we finish these interviews, I might add on to my list of insiders qualified.
Okay, we are noted, Senior Counsel. So we have come to the end of the interview. It has been a long day, and we want to thank you for availing yourself and for the engagement. Senior Counsel, you have been very candid, you've been very honest, and we want to, on behalf of my fellow commissioners, I want to thank you for that. And before you go, I want to ask you whether you have anything to tell us.
On my part, Madam Chair, and all commissioners. It has been a wonderful experience. It has been a pleasure, and I look forward to interacting with you, if not as Chief Justice, as a colleague in the justice sector, as colleagues in the justice sector. So I thank all of you. And I must say, maybe this should go on the record. As I reviewed the tapes of past interviews for the last two Chief Justices, I was very disappointed at how some of them were conducted, or some of how some of the commissioners conducted themselves. I say this because I read again the memo from the KMJ, and they said, please, commissioners, remember that when you interview these brave souls who appear before you, remember that there is a life for them even after they lose. Spare them anything that destroys them and destroys their careers. So I want to say that this series of interviews has been conducted with wonderful decorum, 99.9%, and I'm very grateful. Thank you. We're all human, it can't be 100%.
Thank you very much, and we take that with humility on behalf of the commissioners. So that is the end of the interview. Thank you very much, Senior Counsel.
Thank you. Are they going to go? Are they walking out first?